Something shocking is happening in California right now that almost nobody outside the gun community is talking about. For decades, California has been known as the state with the strictest gun laws in America. Layer upon layer of restrictions, regulations, requirements, and prohibitions that made it incredibly difficult to exercise Second Amendment rights. Gun owners in California have lived under this system for so long that many of them thought it would never change. But over the past 2 years, something remarkable has happened. California gun owners are winning in court. Not just one case here or there, but multiple major victories that are dismantling some of the most significant gun control laws in the state. Laws that have been on the books for 20, 30, even 40 years are being struck down as unconstitutional. And this is not slowing down. It is accelerating. So if you live in California, if you care about gun rights, or if you just want to understand one of the most dramatic legal turnarounds in recent memory, you need to hear this story. Let me walk you through exactly what is happening, which laws are falling, why courts are ruling against California, and what this means for the 40 million people who live in the Golden State. Let me start by giving you some context about California gun laws, because if you do not live there, you might not realize just how restrictive they are. California has more gun laws than almost any other state in the country. They have an assault weapons ban that prohibits guns based on cosmetic features like pistol grips and adjustable stocks. They have a handgun roster that limits which handguns can be sold in the state, and that roster has been shrinking for years because of impossible requirements that even modern handguns cannot meet. They have a magazine capacity limit that bans magazines holding more than 10 rounds. They have a 10-day waiting period for all gun purchases. They have universal background checks that apply even to private sales. They have red flag laws that allow guns to be confiscated without the owner being present in court. They have microstamping requirements that are technologically questionable. They have ammunition purchase restrictions that require background checks just to buy bullets. The list goes on and on. For decades, California politicians passed gun control law after gun control law, and gun owners felt like they were constantly losing ground. They would challenge these laws in court. But California is in the Ninth Circuit Court of Appeals, which has historically been very friendly to gun control. So even when gun owners won at the trial court level, they would often lose on appeal. It felt like a rigged game. But then everything changed. In June of 2022, the United States Supreme Court decided a case called New York State Rifle and Pistol Association versus Bruen. And that decision completely changed the rules of the game. The Supreme Court established a new test for evaluating gun laws. It said that any restriction on Second Amendment rights has to be consistent with the historical tradition of firearm regulation in America. If there is no historical precedent from around the time the Second Amendment was adopted in 1791, then the restriction is probably unconstitutional. This was a massive shift from how courts had been evaluating gun laws before. And suddenly, all those California gun laws that seemed untouchable were vulnerable, because when you apply the historical tradition test, most of California's gun control system falls apart. There's no historical tradition of banning guns based on cosmetic features. There's no historical tradition of limiting magazine capacity. There is no historical tradition of forcing people to wait 10 days to pick up a gun they purchased. California built its entire gun control framework on modern policy preferences and public safety arguments. But under Bruen, those arguments are not enough anymore. You need historical justification, and California does not have it. So what happened next? Gun rights organizations immediately started filing new lawsuits and asking courts to reconsider old cases in light of Bruen. And they started winning. Let me give you some specific examples. One of the biggest victories came in a case about California's handgun roster. This is a law that requires all handguns sold in California to be on an approved list maintained by the state. To get on the list, a handgun has to meet certain safety requirements. But here is the kicker. One of those requirements is microstamping, which is a technology that supposedly imprints identifying information on bullet casings when a gun is fired. The problem is that microstamping does not really work in practice, and no major gun manufacturer has been able to implement it reliably. So because of this impossible requirement, the handgun roster has been shrinking. Newer, safer handguns cannot get added to the roster, while older models get removed. California gun owners have been stuck with a list of increasingly outdated handguns while the rest of the country has access to modern firearms. Well, in 2023, a federal judge struck down major parts of the handgun roster law, saying it violates the Second Amendment. The judge found that there is no historical tradition of requiring government pre-approval before a type of gun can be sold. This was a huge victory because the handgun roster has been one of the most frustrating aspects of California gun law for decades. Another massive win came in the magazine capacity case that I talked about in another video. California bans magazines that hold more than 10 rounds. This law has been challenged multiple times, and it has had a roller coaster ride through the courts. But after Bruen, the case was sent back to be reconsidered under the new historical tradition test. And legal experts are very confident that California's magazine ban is going to be permanently struck down because there is simply no historical precedent for limiting ammunition capacity. When that happens, California gun owners are going to be able to legally possess standard capacity magazines for the first time in decades. That is millions of people regaining a fundamental aspect of their Second Amendment rights. Then there is California's assault weapons ban. This is one of the oldest and most comprehensive assault weapons bans in the country. It prohibits semi-automatic rifles with certain features like pistol grips, folding stocks, flash suppressors, and other cosmetic characteristics. Gun rights advocates have always argued that this law is absurd because it bans guns based on how they look rather than how they function. A semi-automatic rifle without a pistol grip functions exactly the same as one with a pistol grip, but one is legal and the other is a felony to possess. Well, this law is now being challenged under the Bruen standard, and it is facing serious problems. There is no historical tradition of banning guns based on ergonomic or cosmetic features. In fact, the whole concept of an assault weapon is a modern political creation. It does not have any basis in historical firearm regulation. So gun rights groups are arguing that California's assault weapons ban cannot survive under Bruen. And based on how other cases are going, they have a strong argument. If you are realizing just how much is changing in California and you want to stay updated on these court victories, do me a favor right now. Hit that like button to help this video reach more people, subscribe to the channel so you do not miss future updates on these cases, and share this with any California gun owners you know because this is information they absolutely need to have. All right, let us keep going. Now, let me talk about California's waiting period law. California requires a 10-day waiting period for all gun purchases. It does not matter if you already own guns. It does not matter if you have already passed a background check in the past. Every time you buy a gun, you have to wait 10 days before you can pick it up. The stated purpose of this law is to provide a cooling-off period to prevent impulsive acts of violence. But here's the problem. There is no historical tradition of waiting periods. They are a 20th century invention. And courts are starting to question whether California can justify this restriction under the Bruen test. There's already litigation challenging the waiting period, and gun rights advocates are optimistic that at least portions of it will be struck down, especially the requirement that applies to people who already own guns and have already been background checked multiple times. Let me tell you about another area where California is losing. Concealed carry permits. Before Bruen, California was a May issue state in most counties. That meant that even if you met all the requirements, the local sheriff or police chief could deny your application if they did not think you had good cause to carry a gun. This system was incredibly arbitrary. In rural counties with pro-Second Amendment sheriffs, permits were easy to get. But in places like Los Angeles, San Francisco, or San Diego, it was almost impossible for an ordinary person to get a concealed carry permit unless you were wealthy, famous, or politically connected. The Bruen decision specifically struck down this type of system. It said states cannot require people to show special need or good cause to exercise their Second Amendment right to carry. So California had to change. They got rid of the good cause requirement. But then they tried to add a bunch of new restrictions on where you can carry, even with a permit. They created a massive list of sensitive places where guns are banned. And guess what? Those new restrictions are being challenged in court too, and many of them are being struck down or limited. California is learning that it cannot just replace one unconstitutional system with another. Here's what is really remarkable about all of this. California is not just losing one case. They are losing multiple cases across multiple areas of gun law. And each loss sets a precedent that makes it easier to challenge other laws. It is like a dam breaking. For decades, California built up this massive wall of gun restrictions. But now that wall has cracks and those cracks are spreading, gun rights organizations are taking advantage of this moment. They are systematically going through California's gun laws and challenging anything that cannot meet the historical tradition test. And they are winning more often than they are losing. This is creating a situation where California's gun control framework, which took decades to build, is being dismantled in just a few years. Now let me talk about the political response, because it is fascinating. California politicians are not happy about what is happening. They built their political careers on being tough on guns. Gun control is extremely popular among California voters, especially in the major cities. So when courts strike down these laws, politicians feel pressure to do something. But here's their problem. They cannot just pass new laws that violate the Constitution. Courts will strike those down too. So they are trying to find creative ways to regulate guns within the boundaries that Bruen has set. They are looking for any historical precedent they can find to justify restrictions. They are trying to define more places as sensitive locations where guns can be banned. They are trying to create new categories of dangerous weapons or dangerous people. But every time they try something, gun rights groups immediately file a lawsuit. And more often than not, The new restrictions do not survive judicial scrutiny either. It is a game of whack-a-mole where California keeps trying new approaches and courts keep striking them down. Let me give you a sense of what this means for ordinary Californians who own guns. For years, these people felt like second-class citizens in their own state. They had to jump through endless hoops to exercise a constitutional right. They had to comply with confusing and constantly changing regulations. They faced the risk of becoming accidental felons if they did not keep up with every new restriction. And they watched as politicians demonized them and treated gun ownership as something shameful. But now, for the first time in decades, California gun owners are seeing their rights recognized and protected by courts. They are seeing laws that burden them get struck down. They are seeing the legal system finally push back against the political branches of government. It is an empowering moment for a community that has felt under siege for a very long time. But I also want to acknowledge the other side of this debate. There are millions of Californians who support strict gun laws. They genuinely believe that these restrictions make communities safer. They worry that striking down gun laws will lead to more violence. These are legitimate concerns held by sincere people. The challenge is that under the constitutional framework established by the Supreme Court, good intentions and public safety concerns are not enough to justify restrictions on constitutional rights. There has to be a historical foundation. And for most of California's gun laws, that foundation does not exist. So we are in a situation where the political majority in California wants some strict gun laws, but the legal system is saying you cannot have them if they violate the Constitution. That tension is not going away anytime soon. Let me talk about what happens next, because these legal battles are far from over. California is appealing many of these decisions. They're going to fight to keep as many restrictions in place as they can. Some cases will go all the way to the Supreme Court. But the momentum is clearly on the side of gun rights. The Bruen decision established a framework that is very favorable to Second Amendment claims, and lower courts are following that framework. So even if California wins a case here or there, the overall trend is toward fewer restrictions and more recognition of gun rights. Over the next few years, we are probably going to see California's assault weapons ban struck down. We are going to see the magazine capacity ban struck down. We are going to see waiting periods at least partially invalidated. We might see challenges to ammunition purchase restrictions, microstamping requirements, and other regulations. California is going to have to come to terms with the fact that it cannot maintain the most restrictive gun laws in the country if those laws do not have constitutional support. Here is something else that is important. What happens in California affects other states too. California is the largest state in the country with the biggest economy. It has often been a trendsetter for progressive policy. Other states have looked at California as a model for gun control. But now that California's laws are being struck down, other states with similar laws are vulnerable too. New York, New Jersey, Massachusetts, Connecticut, Maryland, they all have gun laws that are modeled on California's approach, and they are all facing similar legal challenges. So California's losses in court are paving the way for victories in other states as well. This is a nationwide movement, and California is at the center of it. Before we wrap up, let me remind you one more time. If this video is helping you understand the massive legal changes happening in California, please hit that like button and subscribe. Share this with anyone who needs to know that the gun rights landscape is shifting dramatically. These are some of the most important Second Amendment cases in a generation, and they are changing life for millions of people. All right, let me bring this home. The bottom line is this: California gun owners are winning. After decades of being on the defensive, after years of watching their rights get restricted more and more, they are finally seeing courts push back and say enough is enough. Laws that seemed permanent are being struck down. Rights that seemed lost are being restored. And this is not a temporary blip. This is a fundamental shift in how courts evaluate gun laws, and that shift is going to have lasting effects. If you are a California gun owner, this is your moment. Stay informed about these cases, know your rights, and take advantage of the opportunities that are opening up as unconstitutional laws fall. If you support gun control, understand that the legal landscape has changed and many restrictions you thought were settled are now back in play. Either way, California gun law is being transformed before our eyes. And it is one of the most significant legal stories in the country right now. Thank you for watching. Hit that like button, subscribe for more updates, and share this video. I will see you in the next one. Stay informed and stay free.